Hello and welcome to the third lecture in the People, Plants and the Law seminar series. My name is Hamish McDonald and I'm really pleased to welcome Dr. Jose Bellido, a reader in law at the University of Kent, as our presenter for today. First, I want to begin by acknowledging the traditional custodians of the unceded lands on which the University of Queensland is situated. I want to pay respects to elders past, present and emerging, and to express solidarity with their ongoing struggle for justice and our hope and belief that we can move to a place of equity, justice, and partnership together. Today's presentation examines a fundamental aspect of intellectual property law, which is the distinction between nature and artifice, or nature and culture. This distinction often demarcates that which can be legally owned from that which can't. Jose explores these unstable categories by analyzing the legal history of copyright in artificial flowers.
Thank you, Hamish. Good morning, everyone, or good afternoon, depending on where you are. Thank you for tuning in. This is a work in progress on the history, not only of copyright of artificial flowers, but also some references to trademarks. I will be making some references to trademarks and to patents. It is a work in progress. And I hope you really enjoy it. As it is well known, intellectual property law has been dealing with botanical innovations for over a century. Even though there is a burgeoning literature on the role in intellectual property, a different type of innovation based on its close resemblance, artificial flowers, has been largely overlooked. This is at first glance surprising because artificial flowers not only have been protected through different intellectual property regimes, including patents, trademarks, and copyright, but their protection has also prompted a considerable number of legal disputes, particularly in the 1960s. What is important to note about artificial flowers is that they occupy an awkward historical position within intellectual property, showing the unstable and contingent character of the distinction between the natural and the artificial. In their attempts to simulate or deviate from nature, artificial flowers elicited interesting questions about traditional categories such as originality, authorship, novelty, and utility. But they also showed that there was more at stake in the industrial approach to nature, namely the possibility to form an intangible or immaterial work that appear like nature and that can be subject of rights and claims. Such possibility has acquired contemporary relevance with the emergence of virtual and simulated realities after the digital and biotechnological revolutions. My talk, however, will concentrate on the significance of artificial flowers in the 20th century to discuss the ways in which intellectual property struggled to accommodate fake flora. Although this study will not provide answers to contemporary questions, current normative anxieties might find in one way or another echoes to their preoccupations in the kinds of concerns prompted by artificial flowers. What lied behind the question of artificial flowers was the making of an intangible invention or an artistic creation from its tangible embodiment, a reproduction or imitation of a natural flower made from a diverse range of materials. While the materials of which the flowers were made played a role in constructing their lifelike appearance, one of the difficulties that artificial flower making had was its overall dependence on manual labor, causing trouble and concerns over the cost of implementing a standardized mass production in this field. The shift from handmade manufacturing to mechanical processes for artificial flower making is hence implicated in a great number of patent applications that attempted to build a modern industry on a mass production basis, and that, in doing so, tried to find, select, and develop a material that could be formed repeatedly, enabling the artificial flower to be made at low cost and attractive to customers. According to some, this meant that the manufacture of artificial flowers furnished an incomprehensible industry, providing both pleasure and profit and employing countless hands and wealth. If we turn our attention to this puzzlement, it is not a surprise to see how artificial flowers were discussed in labor reforms in the West that aim at protecting workers from exploitation. Indeed, as we will see, one of the main reasons for the expansion and the flourishing of the artificial flower industry in Hong Kong was the laxity of its labor laws. By the early 1960s, there were more than 200 factories in Hong Kong engaged in the manufacture of artificial flowers. In 1904, a journalist reported on her visit to an artificial flower factory in London, where it was possible to observe the making of silk, lawn, and velvet flowers. She highlighted that what made the factory especially interesting was the fact that the whole process was carried out on the premises, with all the tools and implements required in the manufacture of artificial flowers being made on the spot. Interestingly, she concluded with a reference to the patent room, where clever heads, she said, were at work on a problem, the solution of which was going to revolutionize the artificial flower trade. Artificial flowers themselves produced that revolutionary aspiration, whereby the relationship between technical problem, and solution constituted the very possibility for an invention to emerge. In other words, patents and patenting activities around these flowers capitalized on the quest for imitation. There is a plethora of applications in patent office records showing that paradox embedded in the very notion of artificial flowers. To fabricate an object so that it resembled a natural flower meant that such likeness appeared both as a claim for novelty and against obstacles for patentability. Although locating the gist of the invention in the ability to closely resemble genuine blossoms constituted the main threat of flower fabrications, there were some interesting exceptions. There were patent and designs applications for artificial flowers furnished on botanical inaccuracies, that is, artificial flowers not known to approximate any known flower in nature. Rather than simulating nature and using real flowers as guiding patterns, departing from them was incidentally perceived as the best way to develop an artifice that could also lay claim on a novelty. In fact, some commentators argued that artificial flower makers would be better off leaving the pursuit of verisimilitude and developing what they described as unnatural flowers, objects that did not exist in nature. That would pave the way for true ingenuity, for an industry that would elicit the fact that these flowers were not born, but formed, owing their fabrication not to nature's way of doing things, but to human imagination. For instance, these fancy flowers imitated natural forms, but of unnatural colors, paving the way for a variety of pleasing effects to be produced. However, as mentioned above, most patents for artificial flowers or their making devices derive their ingenuity from the desire to replicate nature. although they were obviously human-made and their imagination focused on imitation, their worth resided in the way in which human intervention was effaced, so that the invention emerged as if it were a work of nature, a living and fresh flower like the one imagined to be. So here you've got two interesting examples. One is a rose and another one is a pond lily. This can be seen in the ways in which patent applications specified several mechanisms to disguise such intervention. For instance, making wires to be camouflaged, making containers to be concealed, or creating self-supporting structures, or even vases were included and brought into applications to make artificial flowers look even more realistic. In that sense, artificial flowers were manufactured versions whose beauty resided in the capacity to deceive even the eye of a botanist or a florist. The driver of their improvement was undoubtedly simulation. Perhaps for that reason, one well-known patent scholar, Frank D. Prager, saw the relevance of the work of the French sociologist Gabriel Tarde to discuss the modern tendency to create products and processes imitating other materials or articles. Tarde's The Laws of Imitation, published in 1890, drew a distinction between invention and imitation, emphasizing the role of desire, habit, and fashion at the center of the imitative impulse. Although Prager considered that depending on the type of imitation at stake, its legality could be compromised, he ended up highlighting that there was no serious rule that would exclude an imitation from the field of inventive solutions of technical problems, that is, from patent law. But what were the technical problems that artificial flowers tried to overcome? On the one hand, simulating flowers in patent applications involved the production of desired natural effects. For instance, patent applications claim novel ways to produce the vain look of natural dropping leaves, improvements in the manufacture of simulated petals, and different ways of making artificial flowers, stems, pistils, and calyces. By looking at flower construction as a model, patent applicants tended to focus on the details of its constituent parts, shaping their inventions and their functional features in ways to assume the characteristics of a natural flower. In doing so, they allegedly avoided grotesque imitations, and in turn, they were able to claim that their invention presented as nearly as possible the natural shade of flowers. On the other hand, it is possible to see how the making of artificial flowers began to privilege certain kind of patent improvements, not only the visual resemblance to naturalness, but also the possibility to overcome its limitations. This can be seen in applicants' references to the purposes for which these flowers were made and the advantages they might yield. While some applications argued that the artificial flower could serve to teach students about nature, and others highlighted their decorative and ornamental uses, there were also several other applications emphasizing specific conditions that made artificials different and even more useful than the fresh flowers. The point of these inventions was that they tried to sustain original shapes and beauty regardless of variations in climate and in temperature. Similarly, simulations of flowers aspire to have the benefit of blooming at all times of the year, because these inventions aim at having the appearance of genuine flowers, but with the advantage of long service life. Some commentators began to describe them as permanent botanicals. The stigma of fake, cheap, and insincerity have always haunted the consumption of artificial flowers. The main reason for that dishonor was that they failed to replicate nature beyond its visual features, precisely because of fresh flowers being subject to change, decay, and death. There were also other characteristics of flowers that artificials struggle to imitate, such as their smell. Although novel means for incorporating perfumes and odor had also been patented, this is often raised against artificial flowers, making them the same but not the same as their natural counterparts. Despite or precisely because of this, it is interesting to consider why artificial flowers rose to prominence in the 20th century and how law was implicated in that social acceptability. In part, the reason for their increasing popularity and for their attracting different claims of intellectual property protection for both indoor and outdoor settings can be traced not only to their attempt to resemble nature, but also to other historical, legal, and cultural factors. By far, the most notable development that took place in the first decades of the century was the rise of a particular kind of artificial flower, the poppy. The making of artificial poppies became a way to commemorate the loss of life after the First World War. The preference for this flower was obviously its color, representing blood, and the benefit of creating monopolies for its manufacture and distribution was deemed beneficial to employ ex-servicemen and war widows. Selling replicas of poppies served to raise money for the welfare and support of war veterans and widows. And interestingly, copyright and trademarks began to play a significant role facilitating these charitable endeavors. One particularly important reason for this can be traced to their function as guarantee of origin and to provide a platform for merchandising activities. According to some commentators, such schemes were not inappropriate because artificial flowers were indeed made by disabled or needy ex-servicemen, most of whom led somehow artificial lives. The second development that enhanced the value of artificial flowers was their use in environments where fresh flowers could not survive due to their perishable condition. In that sense, artificial flowers began to proliferate as indoor decorations because of the advantages which they offer over natural flora. For instance, they were used in clubs, hotels, and restaurants where natural flowers would quickly die. Similarly, imitative flowers proved to work better for photographic and cinematographic purposes, better than genuine flowers, making them a favorite prop in Hollywood, where technicians created reality in movies. Artificial flowers became necessary in filmmaking as the intense heat of lamps and the fact that sequences in which flowers appear could take weeks to be filmed and therefore would make fresh flowers to die and become useless. This shift in the attitude towards artificial flower consumption was also enhanced by a third development concerning their domestic use, the emergence of the flower arrangement movement in the 1930s. Flower arrangers such as Constance Spry in Britain or Mike Danilo in the United States led a movement based on the appreciation of rootless flowers, both natural and artificial, selected and arranged for decorative purposes. By placing the creative emphasis on the decorative view of the arrangement, rather than the origin of the flower, this movement, and artificial flowers as well, emphasize the worth of flowers for their visual and aesthetic features instead of other characteristics that a flower might have. In fact, the idea of a flower, of considering a flower as a sculpture that emerged as an argument in some of the copyright disputes that will be mentioned later, is connected to this perception because it was based precisely on the visual effects that an arrangement or an artificial flower could achieve. While the factors mentioned before contributed to a new popularity of artificial flowers in the 20th century, there is another development that was even more significant in making them ubiquitous and commercially attractive. One of the challenges for artificial flower makers was to find suitable materials that could be bent or folded to keep their curvatures and forms for a long time. For instance, bending the material downwardly was one of the ways in which leaves of natural flowers could be simulated. The invention of polyethylene had a considerable impact, both in nurseries, normally in nurseries as plastic pots or plastic sleeves covering crops, but also in their artificial counterparts, paving the way for a number of interesting patent applications where artificial flower making finally claimed that their inventions could be mass-produced at a relatively low cost. These applications evidenced how flower structures prefabricated in plastic simulated fresh flowers and their characteristics. For instance, petals could be molded in one single injection using the living flower as a model. Plastic could also be colored to imitate exactly the many natural color tones of the fresh flowers. Artificial flowers constructed of plastic grew exponentially in the late 1950s, and several manufacturers and distributors seeking to commercially exploit them started registering them in the US Copyright Office. The reason why these registrations proliferated is seen as a legal development after Maser versus Stein, 1953. Maser versus Stein is a landmark copyright case from the US Supreme Court that handed down a decision that three-dimensional articles could be copyrighted, permitting the overlapping of copyright and design patents. Although there is a considerable amount of scholarly literature regarding the case, there is, or the remarkable aspect of the decision was the way it was understood as affirming the shift in practice that had taken place earlier in 1949, that meant that commercial use did not invalidate copyright, and hence copyright registration for items such as dolls, jewelry, textile fabrics, and artificial flowers was allowed. A quick glance to the registry in the late 1950s and early 60s shows the coexistence of protection in relation to artificial flowers, epitomized in the figure of inventors such as Alfred Jim Fristot and André Emile de Camp, that were patent applicants, being also listed as authors of floral creations. Late in the 1960s, the registration of hundreds of artificial flowers, including dahlias, violets, roses, hyacinths, and lilies, was accomplished, a trend that did not pass unnoticed in the Copyright Office, which acknowledged that the number of deposits in this field had increased spectacularly. Interestingly, these registrations did not cover the process of manufacturing, but the creation itself, and testified to the fact that artificial flowers were being considered a proper subject for copyright beyond their patentability. What made polyethylene remarkable for artificial flower making was that the flower created never lost its original shape. That is, that once molded, it was always going back to its molded form. Such material property, often described as plastic memory, provided reliability, durability, longevity, and flexibility to the simulations, attributes that the industry for artificial flowers would cherish, but that had, as we all know, a dreadful impact on our ecological condition. One of the reasons for the success of plastic flowers was that polyethylene accurately duplicated nature in every detail, while at the same time facilitated industrial standardization and uniformity. In other words, the artificial flower created was reproduced identically after each plastic injection of the machine. There are, of course, similarities here with the way in which companies such as Lego use these properties of plastic to elicit an image of quality for its toys that was then marketed by retailers and distributors. But the main difference is that the material for the making of molds was nature itself. In fact, many artificial flower factories, such as CalArt in California, had a garden in the backyard that functioned as a studio or a workshop with models for making accurate reproductions. Many plastic flowers were made outside of the United States because of the relatively inexpensive labor cost for manufacturing and assembling such items. The material attributes mentioned before and their low cost also facilitated their movement and circulation, making them an item that could be subject to long-distance shipments. Although artificial polyethylene flowers and foliage were manufactured in countries such as France, Italy, Puerto Rico, and Japan, Hong Kong quickly emerged as the main exporter of these goods, being labeled as the world's largest nursery of plastic flowers. The uncertain status of copyright in Hong Kong where the British Copyright Act of 1956 had not been extended, also contributed to the perception that the plastic flower trade offered genuine business opportunities. If we pay attention to the copyright registrations that were accomplished in the early 1960s, it is possible to see that one of the most active applicants, with almost 130 entries, was Ricoh Limited. Ricoh Limited was an American company that had established a branch in Hong Kong to import these imitation flowers. According to the internal correspondence between the British Embassy in Washington and the Board of Trade, the practice of registering copyrights by this company was a strategy to virtually preclude the supply of these flowers to the American market, except through Ricoh's direct selling or a royalty arrangement. In other words, Ricoh Limited had started registering copyrights to develop a licensing system to control, as much as possible, the market of artificial flowers. What raised such a suspicion was not only that the company began acting as an intermediary between Hong Kong manufacturers and American distributors, but also that it was strangely connected to another company, Intercontinental Inspection Services, that had written to US importers of plastic flowers offering dealers' rights in flowers copyrighted. Moreover, Ricoh Limited did not stock any plastic flowers in the United States, but was aimed at operating its business fully on the basis of the advantage afforded by copyright. Interestingly, the company also used trademarks to differentiate their products. It had arranged to use the trademark Constance Spry, the well-known flower arrangement company, to market its artificial flowers. In January 1961, shipments of Hong Kong plastic roses and geraniums were impounded at the docks, marking the beginning of a long list of legal conflicts that emerged regarding artificial flowers. The collector of customs had the obligation to consider whether those imports were actual copies of substantial reproductions of legal copyrighted articles. And in doing so, the copyright registrations were important, since a certificate of registration could be filed with the Bureau of Customs so that the importation of any article that might infringe the copyright could be stopped. Customs regulations provided the possibility that any interested party, such as an importer, could deny that his product was an infringement of copyright, and in such a case, the copyright holder was forced to post a bond. Otherwise, the product was allowed to pass through customs in the normal manner. What is remarkable is that the Bureau of Customs found particularly difficult to differentiate between originals and copies in relation to artificial flowers, and occasionally submitted samples of both the copyrighted flower and its presumed infringement to botanists. The idea behind that expert referral was to elucidate if the number of identities between them could occur randomly, both in nature and its simulation, and to consider whether manufactured items themselves varied from nature in its technical details. Moreover, the Bureau also paid attention to the way in which plastic flowers were manufactured to come to a decision. The making of plastic flowers involved two main processes. As mentioned, the basic components such as buds, cores, petals, calyces, stems, and leaves were formed by injecting polyethylene into molding machines, and a variety of molds was available to reproduce the shapes and the sizes of natural flowers and foliage. But then these components were assembled by hand. To ascertain the existence of copying, customs officers resorted to a petal test, which often demonstrated copying if the several tiers of petals fit together, vein for vein. Petals, and the way they were arranged, were usually the most distinctive feature of plastic flowers, and their forensic examination enabled the possibility to decide whether a flower was whether an artificial flower was an infringing copy or not. The problem of the petal test was, however, that it seemed to depart from the legal test, as some courts have occasionally repudiated dissection of articles to establish copyright infringement, while some argued that the petal test was consistent with the legal test, the ordinary observer test. The difficulty in distinguishing the original and the copy was exacerbated by several factors. First, importers of plastic flowers began registering copyrights themselves too, as a defensive strategy against RICO Limited. And you can see many copyright registrations made by Corvosco, that is a company that was manufacturing flowers in Italy, Prestige Floral, that was a company that was making flowers in France, etc. So it's not only RICO Limited that that register copyrights for artificial flowers, but also other companies started doing the same. Secondly, these importers also started asking manufacturers in Hong Kong, when they were buying their produce in Hong Kong, they were asking them to include copyright disclaimers in their shipments. And third, customs officers became more and more reluctant to exercise complicated analysis because they considered that beyond their competence, and also because of fears of being sued. After the initial controversy in customs, the problems created by copyrights reached the courts a few months later. The first case dealing with the copyrightability of artificial flowers was Prestige Floral versus California Artificial Flowers in 1962. Interestingly, the judge held that although a flower, like a dog, is a creation of nature, a likeness of it might be copyrighted. The decision was instrumental in confirming the earlier copyright practice of registering artificial flowers, insofar as they could be protected beyond their patentability. In a sense, Judge Feinberg did not say anything particularly remarkable, but shifted the focus to the question of originality. He said that since plaintiff's lilac reflects originality and a substantial degree of skill and independent judgment, it is a proper subject for copyright. While the decision seems clear in principle, it did not stop the legal controversies around plastic flowers. More than half a dozen of cases concerning them reached the courts in less than a decade. Although this unusual number of cases has attracted the attention of some commentators, their discussion often centers on the normative dilemma between design and copyright. Such focus restates the difficulty inherent in notions of originality and creativity, but neither it does explain the repetition of legal controversies, nor how they evolve historically. Two artificial flowers decided immediately after Prestige Floral versus California Artificial Flower ended up with the court denying preliminary injunctions on the ground that the similarities between the works might be the result of their both being reproductions of living flowers. Here, we can see how nature occupied a central pivotal role to decide whether copyright was infringed. But the most important feature was that nature was invoked or imagined differently by the parties, and depended on the ways in which it was studied, described, and brought into the courtroom. For instance, one of the judges in those cases noted how he had studied the polythylene flora in evidence, rhododendrons vein in France and in Hong Kong, together with the parties' aesthetic, metric, and horticultural contentions about them, to conclude that although the two flowers were by no means identical in overall appearance, the distinguishing characteristics were wholly insufficient to conceal the substantial copying that adds up to infringement. One of the problems that the focus on infringement had to grapple with was the fact that it is based on comparison between specimens. This posed evidential difficulties, some of which were generated by the Copyright Office itself, that allowed for an optional deposit of the copyright work. As copyright registrations of artificial flowers began to be the subject of many inquiries, there are some references in the cases of the chaotic condition of the office, not being able to provide or locate the specific items litigated because they had been misfiled. Although these problems were solved by the plaintiffs themselves producing notarized replicas of those submitted to the office, the point that they elicit is that the law had difficulties to capture the temporality of nature itself. In fact, the living model used and applied to the molds was even more important than the replica, constituting the most crucial evidence in these controversies. For it was too much of a coincidence that both the plaintiffs and the defendants had used the same lilac, rose, or geranium for their floral creations. To the extent that nature constituted the model from which artificial flowers were created, the point argued was that no two flowers will grow alike. For instance, any single lilac from hour to hour will appear different, making it inconceivable how someone in Hong Kong and someone in France could have identical lilacs before them, and how they could come up with the identical rationale in assembling the parts, how they could come up with the thought of only including two size flower petals, only one size bud, and only two sizes of leaves in the flower blooms. There is also a final reference to be made in relation to a procedural characteristic of these cases. This can be seen in artificial flowers catalogs, featuring types of flowers normally associated with specific seasons. For instance, lilacs in spring being introduced as copyright evidence. It is quite curious that most of the plaintiffs emphasize the importance to prevent an imminent infringement from taking place, and hence ask the courts for injunctions to impede the selling of flowers by the defendants. One of the reasons argued was, ironically, that the business of artificial flowers was a seasonal trade in a similar way to that of fresh flowers. What we can see in these cases is how artificiality and naturalness shaped each other in the way nature was stylized, in the difficulty to distinguish between original and copy, and in the development of an industry in which being was based on appearance. Thank you.
Does anybody have any questions for Jose?
I really like the paper, but I just got some questions, which because I don't actually understand some of the early history in particular, but I wondered if you'd actually looked at comparisons of the early designs put forward for patents to designs that were already pre-existing in floristry and haute couture, because there's silk and lawn accessories on dresses and hats, which become really popular in the late 19th century, early 20th century. And so I wondered how much of simulation compared to nature is one discourse, but how much is also a patent discourse, an attempt to distinguish artificial flowers that are actually being made and copied from other industries where there's not a lot of professionalization. And so in that sense, they already have a reasonably weak intellectual property exposure. And then when we move on, I wondered how much exchange there continues to be with the professionalization of floristry, because Constance Spry, for example, is actually not famous as a plastic flower maker. She's a true florist using perishable flowers. So I was just wondering about, say something more about that connection. And also I wondered, are there any French cases? Because in French, obviously there's a lot more respect for artistry and fashion, and Veronique Pollard's book on fashion suggests that we have to be careful comparing French and US approaches with respect to things like fashion, and you were sort of pitching flowers as a fashion. And so another side thought about that, my last one, is to what extent is it about the US that generates litigation? Why is there litigation in the US and not in other places? Thanks.
Great, thank you. I don't know if I have taken all the questions. I have written the questions down, but let me know if I miss anything. But one of the questions that you were asking is about florists. I think there is a tension there, or a question that some florists had, that was whether the artificial flower market was a competing market, and therefore they were not very keen on having artificial flowers in their shops. I think there is, in the 60s, there is a small shift or change, because artificial flowers were also being distributed in department stores and other places. So florists started seeing that as a side for their own business. And also there was an argument that people were coming into their shops, and that the consumer of artificial flowers was not the same as the consumer of fresh flowers, because perhaps it might have been a different class, because they were less expensive, etc. So there's certainly a subtext or another historical layer there about what is the relationship of florists with artificial flowers. What is the relationship of horticulture with floriculture? That I didn't want to get in so much. If you take the competitions of in natural flowers in the Royal Horticultural Society, you can see that one of the prohibitions always was against artificial flowers. So not to make combination of artificial flowers and fresh flowers. So they were this stigma that they were bad, fake, and cheap, I think it's also in that type of relationship between florists. But I think perhaps I didn't mention much about this notion that flowers, artificial flowers, were seen as a sculptural form, or as appreciated for their visual effects or characteristics, that I think is connected to the way in which flower arrangers also appreciated flowers, cut flowers, both natural, in the natural form and in the artificial form. So I think there is a changing attitude toward artificial flowers that is connected to the history of the flower arrangement movement. Then you were asking about French cases and the history of fashion and design, and to be a bit more careful and nuanced about this. And I agree. I mean, I think that one of the problems I was trying to avoid in all the talk and the paper was to get bogged down to the distinction between design and copyright, between patents, design patents, copyright, because that there is certainly a lot of doctrinal history about that, about questions of utility and decoration, and what is the purpose of this creation. So I try to, I think I have tried purposely to avoid that, to write the history more from the context of what exactly, how this utility is connected to what are the expectations in the simulation of nature embedded into these flowers. So perhaps I should go back to that history of fashion and design, and to be a bit more careful and and not to try to avoid the question as it was. So thank you for that. Then I think you were talking about US litigation. I think the US litigation is really connected to that move that is about using copyright as a merchandising platform. So it's similar to the stuff that we have been working on in our book about toys and children. It is the idea that you can use copyright not only to protect subject matter, but just as a franchise mechanism, or as a platform to create a network of contracts and a distribution network. So I think the position of that company that I mentioned, called Rico Limited, was crucial in starting this trend. Then, as history is always an accumulation of accidents, what happened is that Rico Limited stopped trading because two or three of the president and vice president, they just were killed in a flight accident in 1962. But nevertheless, that move that they did was reacted by other companies, that they said, okay, we don't want our shipments to be stopped at the dock, so we just register copyrights and let's see, and we just put copyright notices and trademark notices. So they started seeing copyright and trademarks as a way to build up their businesses as well. So it was a US litigation because of that contingent element in history. Also because I think US was the the most important consumer of artificial flowers. This might be also related to climate. It might be also related to history of the US and to some of the aspects that I mentioned, such as their use in films, such as the development also of department stores, etc. So was there any other litigation? There are incidentally some other cases in Germany in the 1930s and in France, but not as frequent as having a dozen of cases in one decade, like the one in the 60s in the US. Some of these cases, the French case and the German case, were decided similarly in the sense that there is a statement saying, okay, you can copyright an artifact that is based on nature. There is no problem with that at all. It is more or less like a painter painting a landscape. However, some of the 1960s cases, as I was trying to explain, the manual labor almost comes at the end, at the assembling phase, and not at the making phase. It's really machine-based labor. It is mold making labor, and in that sense, the artistry had difficulties to be evidenced.
This is from Tad Brown. I'm curious to know if our distinguished speaker found any geographical differences in arguments for the nature of artificial flowers, given the environmental demands of the cut flower industry. The major cases cited made reference to California. Did copyright protection congregate around specific regions in relation to that of fresh flowers?
Did copyright protection congregate around specific regions? I think the cases made reference, the copyright case made reference to geographical differences, certainly. For instance, the Lilac case, one of the questions that was repeatedly in court was, there is something dodgy about doing lilacs in Hong Kong. Do you have lilacs in Hong Kong? And the point was, I think the point that they were trying to investigate is that someone in the US or in another country had brought with themselves the samples of living models to be made in Hong Kong, just to I think find out access to copy for copyright infringement. So there is certainly some references to how you end up doing these flowers if they are not basically grown in this country. That could be considered to be circumstantial evidence that it was a copyright infringement.
Jose, I have a question. You described some kind of defensive copywriting practices being used where to preempt legal action, manufacturers or producers of cut flowers would take out copyright kind of preemptively. Did you find any evidence about how successful that practice was, or whether it was widespread or more of an anomaly?
I think the defensive strategy was to avoid being stopped at the docks. So it was successful in making customs officers risk averse, because they said, okay, if they have registered copyright, we are not going to say otherwise. So we assume that it is a valid copyright. So and also one of the cases that I listed that perhaps I should have paid more attention explaining them their differences. One of the cases, the customs officer was sued for not stopping illegal copies. Then I think in the middle of the procedure, they decided to drop that claim. But it was the idea that the custom officer was obliged to investigate whether they were illegal copies. Customs officers, they said that with flowers, it was much more difficult than, for instance, a book. Because a book, they were opening the book and they say, okay, this is a facsimile. And I found interesting how they resorted not only to the Copyright Office, but also to botanists to say, okay, if this is a flower that is exactly the same as the other one, what are the reasons for these similarities? Are these because they are both roses, and how many petals a rose should have? So I think these type of questions, they also diverted to expert advice, and because they were afraid of being sued.
So from Susanna, that was such a cool presentation, Jose. Thank you. I suppose I have a couple of questions. So much of what you presented is really happening in the mid-20th century. What sort of copywriting of flake flowers is happening today, if anything? I might let you answer these one at a time, Jose.
Yeah, thank you. I haven't seen recent litigation. I mean, obviously there are cases concerning, for instance, gardens that echo some of the questions that I think they were asked in this sort of cases. And that type of phrase, that type of statement made by Judge Feinberg in Prestige Floral is actually repeated like a mantra in many copyright cases later on. That is, it is more or less like a dog, a creature of nature, but the likeness of it might be copyrighted. I mean, it's such a great phrase. So it doesn't say much, but it tells you, yes, the reason that is the material source of your inspiration is nature is not an obstacle for copyright protection. And many, I think most textbooks and many cases afterwards, they repeated that phrase. The problem obviously is what exactly is a likeness and how you can distinguish between the likeness between being and appearance. Particularly also if you take the development of horticulture in the 20th century, that it becomes quite difficult to ascertain what type of flower this is still. And then the burning question I have is whether or not this research has led you to reflect on the relationship between similarity and difference, and as it is adjudicated in plant patterns and plant variety protection. Yeah, I had, and I deleted this morning, a slide about the parallel between Plant Patents Act and if you were seeing some of the terminology was playing on that, like propagation, etc. But then I realized that most of you work on this history, and I was afraid of being put on the spot on that history. So yes, I think there is much to be said, and there is certainly connections between fresh flowers and artificial flowers. I think for some philosophers, a cut flower is already an artificial flower, and a cut flower already is rootless, and it is taken away from from its environment. So it would be interesting to turn their research upside down and to look at not only what horticulturists or botanists said about this, but also to try to question even more the distinction between the artificial and the natural. So yes, I think there is also something interesting about the logistics in protection and some of these tests to distinguish between similarity and difference. For instance, I think that copyright registration allowed that possibility to deposit samples of three-dimensional articles, created a further obstacle that is that was also perceived and being said by customs officers. That is, some of the flowers were a photographic reproduction, and some of the samples were a three-dimensional article, and say we cannot actually figure out with a photograph the similarities and differences between these two commodities. Jocelyn, could you talk a little more about the expert role that botanists were being called upon to play? Or was it just for customs officers, or were they brought into some of the court cases too? What kind of assessment were they asked to make, comparing the copyright registration with the allegedly infringing articles or something else? Thank you, Jocelyn, and thank you for attending. Thank you for the question. I think I haven't found much about the botanists experts, but just some references in someone who is an expert in customs office history. I think botanists were obviously called when there were natural flowers, cut flowers being traded. They are still being called. So you will see them in Australia, in the US, as part of the Bureau of Customs personnel. But in relation to the copyright infringement cases or at customs, I think they were called to be able to say what exactly a dahlia or a rose look like. And taking that knowledge, how can you explain the similarities between what is supposed to be the copyright registered flower and the flower that is alleged to be an illegal importation? So they were, I think the combination of botanical knowledge was used to infer what is the reason between coincidences and similarity. Is the reason that that obviously a rose looks like this? So I think, and that is kind of interesting. I haven't seen much botanists being called in the litigation. I have to look back again to the transcripts. Obviously, in the judgment, there's no much reference to them, but in the archives, in the hearings, I have to go back to see whether some of them they were called. However, botanical knowledge and botanical accuracies were a recurrent feature in some of these cases. So, for instance, what type of lilacs you have got? There are more than one variety, obviously. So this type of questions that were being asked to botanists at customs also is repeated in cases. I think the reason why it was also appearing in customs is because of that fear to be sued for professional negligence. So it's sometimes you go to experts not just because you want to know, but it's because you want to evacuate the possibility of being sued. But thank you. I will look back to that material, and I think that deserves more explanation. And so thank you for raising that point. That is what exactly botanists were doing and what was the remit of their call.
Final comment from Jocelyn. Great talk. Really enjoyed it and look forward to reading the final paper.
Thank you.
And on that note, thank you so much, Jose, for your time and for a really interesting presentation. And thanks everybody
Thank
in
you.
the audience. Thank you and bye.
Thank you.